You brought a lawsuit against your doctor for medical malpractice, and now your case goes all the way to trial. At trial, you are being questioned by your attorney, and now you forget the answer. Can your attorney use your pretrial testimony to refresh your memory about something that you've now forgotten? You want to know the answer? Come join me for a moment as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, you sued your doctor for medical malpractice. You believe that he was careless, causing you significant harm and injury. Well, the defense says, hey, I did nothing wrong. Why are you suing me? And if I did something wrong, so did you, Mr. Patient. And then they say, you know what? If I did something wrong and so did you, guess what? Whatever I did didn't cause your injuries. And then the doctor turns around and says, you know what? If I did something wrong and you did something wrong and maybe I did cause you some harm, guess what? Your injuries really are not as bad as you claim them to be. Well, in your case, the doctor says, hey, I am never settling your case. I'll see you at trial. Terrific. 2 or 3 years down the road, because that's how long these cases typically take here in New York, now your case gets started. Your attorney calls you as one of the witnesses in your own trial. And now you're up on the witness stand. And your lawyer is asking you questions, open-ended questions. Hey, Mr. Jones, tell us what happened next. What did you do then? And then, what happened after that? So he's giving you an opportunity to go ahead and explain and tell the jury, in your own words, exactly what went on. And what did you do next? And where did you go then? And what did the doctor say? Giving you that opportunity to talk. Now, there may come a time where you simply don't remember something, even though you have reread your testimony that you gave a year or two earlier during pretrial question and answer session known as a deposition that took place in your attorney's office, where the attorney for the doctor had a chance to question you in the conference room. Now, if you remember, there was no judge present, there was no jury present, but there was a court stenographer in the room, along with your attorney, to record all of the questions that you were being asked and all of the answers that you gave. And in preparation for your getting up on the witness stand to testify at trial now, you went ahead and reread the testimony that you gave, the answers that you gave in response to questions you were being asked by the defense lawyer. So now still, you're up on the witness stand, your lawyer asks you a question, and you're just like, shoot, I don't remember. Can your attorney now go and get the transcript of the testimony that you gave, the answers to the questions that you were asked a year or two earlier during your deposition, your pretrial question and answer session? And now turn to the jury and say, Mr. Jones, isn't it true that you gave pretrial testimony about a year ago? Yes, it is. During that time, the defense attorney had a chance to ask you questions. Isn't that right? Yes. And you answered those questions, right? Yes. And you did that truthfully, correct? Yes. And you had a chance to review those questions and answers before you got up on the witness stand today, right? Yes. And now I've asked you a series of questions that you simply don't remember. Isn't that true? Yes. I'm going to read a section of this to you and ask you whether this refreshes your memory about the question you were asked and the answer that you gave. Okay? And now he's going to say, okay. Now, ladies and gentlemen, page 17, line 3. And now I read the question. Answer. And now I read the answer. Mr. Jones, does that refresh your memory about the question that you were asked and the answer that you gave? Now, can I do that? The answer is yes, I can. Does that refresh your memory? If he says yes, terrific, now I can move on. If he says no, it does not refresh my memory, now I can try and ask a couple other questions from the transcript to see if that refreshes his memory. Or maybe there's some other document or a letter that I can now show to him that might refresh his memory. Now, if that doesn't work, what do? I'll tell you what I do. I move on, because I don't want to sit there for 10, 15 minutes trying to get this guy to go ahead and remember something that he clearly doesn't remember. Now, likewise, the defense attorney can try and do the same thing. If during cross-examination he asks you a series of questions that now you don't remember the answer to, but yet a year earlier when he asked you those same questions, you knew the answers. Hey, Mr. Jones, isn't it true that you and I spoke a year ago at your deposition? Yes. I had a chance to ask you questions. Isn't that true? Yes. And you gave me answers. Isn't that true? Yes. And you swore to tell the truth, correct? Yes. And there was a court stenographer there to record all of my questions and all of your answers. Isn't that true? Yes. And in preparation for coming here today to court to testify, isn't it true you reread your deposition transcript? Yes. And when you reread the transcript, did that help you refresh your memory? Yes, it did. So now, let me turn to page 3 or page 17, line 3, or whatever page it is. Question. And now he asks the question. Answer. Now, does that refresh your memory of the question that I asked and the answer that you gave? And again, either it does or it doesn't. So why do I share this great information with you? I share it with you just to give you an insight and an understanding of what really happens in these medical malpractice cases, these accident cases, and these wrongful death cases here in the state of New York. You know, I do understand that you're watching this because you're trying to learn about how your type of case works. Well, if your matter did happen here in New York, but you have not yet started a lawsuit and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.